Hello, welcome back. We've been speaking about justice and we're reaching the end of our transmissions for this season of justice. And one topic really remains to be spoken about, and it carries with it a big long word, but it doesn't need to intimidate us. The word is jurisprudence, and we want to delve a bit into the meaning of that word and the significance of that word for our inquiry. Jurisprudence could basically be taken to be the philosophy of law. And like other subjects where you have the philosophy of something, we are looking at essentially what law is, maybe what it should do, law in the general more than in the specific, because most lawyers are concerned with how to apply the law of their land to specific cases. But the practitioners of jurisprudence, who are a kind of breed of philosopher, ask about what law is fundamentally and generally. Now, we have spoken about what justice is, and we're now sort of shifting more to what law is. We did explain, well, in this program of teaching that is being put out, a connection between justice and law. But we need to note that in the field of jurisprudence, there are a lot of thinkers who don't think there is a necessary connection between justice and law, or morality and law. And we're going to have to sort of re-establish a basis, a philosophical basis for making this connection, which I think is necessary. With jurisprudence, you have juris, which means of the law, and prudence comes from prudentia. We have that word prudence in English, which is the virtue of being able to make practical decisions that are wisely discretionary, to be able to deal with things with discretion, with wisdom, with caution, with balance. So it's not just about the law, but it's understanding how to apply it. Now, jurisprudence is something, of course, that people study in law school, but we're not going to be looking at it in that formal way. We're going to be looking at it as aspirants that want to understand the framework of peacemaking and what jurisprudence has to teach us about it. Maybe we should go back to Martin Luther King Jr., who spearheaded the civil rights movement in America in the 60s. And remember, in the early days, he got arrested for his leading of non-violent protests to the segregation laws. You remember all that?
Just gets arrested for non-violence.
Yeah.
It's funny.
The non-violence was considered to be very threatening.
Oh, God.
Because it was opposed to existing laws about segregation. How people with black skin and people with white skin couldn't go to the same school. They couldn't
sit on a bus together.
Couldn't go to the same establishments, have a drink together, or even drink at water fountains together, or the same water fountain.
My God, how backward.
So anyway, in 1963, he was thrown into Birmingham prison in Alabama. And from there he wrote a very famous letter, the letter from Birmingham prison. And that letter became a bit of a manifesto for the civil rights movement and for civil disobedience. Because he says a number of things in there, one of which was, I agree with St. Augustine, who said that an unjust law is no law at all. Basically, King was saying that when a law is unjust, and we have to inquire into what that means, then you're not obliged to follow it. In fact, it may be even incumbent upon you to disobey it in the name of a higher good. Now, I think this example highlights a kind of schism or separation that exists in people's thinking about the law. Does law have anything to do with justice? There are eminent jurisprudence theorists and people in the law over the last 2 centuries, 3 centuries, especially in the last century, who said that, no, we must simply be descriptive of the law. The law doesn't have any necessary connection to justice. The laws are just what's been established. Law is what has been legally established. It's what human beings have forged as law. It's what the lawmakers have voted on as law. It's what people follow. They just follow it because they're the rules. And we don't need to forge any necessary connection between law and justice or anything higher. This is called legal positivism.
Law, justice.
Well, just think about it. It is the dominant theory about the law today that essentially law is just a sociological phenomenon, expressive of the thoughts and actions of human beings. It shouldn't be compared to standards of morality. It's not about what is normative or right to do. It doesn't have to embody justice.
It's warped.
It's essentially the laws we make. Whether they're warped or not, you can say, well, there are unjust laws and just laws. Some laws are better than others, but essentially the law is the law. And legal positivists are not devoid of morality. They don't have to be devoid of morality. They can recognize that some laws are better than others. Some laws are bad laws, some laws are good laws. And we can change and reform laws, but the law is simply what human beings have made. And another way that I look at it is they're the permissions that the lawmakers have extended to people. And so if Parliament or the law courts haven't given you permission to do something, you can't do it. If Parliament or the law courts try to enforce something on you that's against your conscience, it's still the law, and it has the force of law. And this is problematic, of course. What happens, for example, if your conscience tells you something other than what the law is telling you to do? What do you think of the example of Martin Luther King Jr., who identified unjust laws? He thought segregationist laws were unjust, and therefore he could defy them, break them peacefully, and lead other people to break them. He was despairing that the legal system, the way that it was taking too long to reform things down in the South, in Alabama, and the old guard was holding on to its positions, the old guard of lawmakers, and they didn't want to make way for a new generation of thinkers. And President Kennedy was sympathetic, but things were taking time. Now, a lot of people disagreed with him. The law is the law, and it's incumbent upon you to obey the law because that's the law of the land. But of course, Martin Luther King Jr. had forerunners, precedents. One was Mahatma Gandhi, who made non-violent civil disobedience famous in his campaigns against British colonialism. And before him, of course, Jesus was, you could say, was acting on the same principles, because there were a lot of rules and regulations and laws that the Pharisees of his time were trying to enforce. Rules and laws around the Sabbath, what you could do, what you couldn't do. And they were incensed eventually that he wasn't following the laws. He wasn't playing by the rules. He seemed to be playing by another set of rules. He claimed a higher set of rules. And Jesus, Gandhi, King, they did not view themselves as rebels or anarchists, but as upholders of the true law.
Came at a huge cost to the three of them.
That's right. The three of them were assassinated. Jesus was executed, and the other two were assassinated.
Martin Luther King had his head blown off.
That's right.
It's horrible.
So, for somebody who thinks like them, to be truly lawful and upright is to disobey a bad law and to affirm what Mahatma Gandhi called satyagraha, the truth force, the power of truth.
Was Gandhi assassinated?
Yeah, he was assassinated too.
So.
He was assassinated by a Hindu extremist who thought that Gandhi was giving too much power away to other groups because Gandhi wanted a more or less a secular democracy where Hindus, Sikhs, Muslims and all the different groups could work together. in a kind of brotherhood. And for the separate groups who wanted power in their own right, this was seen as terribly dangerous.
Right.
So even though Gandhi was born a Hindu, it was a Hindu who eventually assassinated him.
Oh man.
Now, it's my position that there has been a degeneration in the law which has followed a degeneration in our knowledge base. If you think about knowledge, it has become compartmentalised, highly compartmentalised today. It's a trend that's been accelerating since the European Enlightenment, although we see signs of a reversal today. Each area of knowledge has become its own separated fiefdom, and there's very little communication between them unless you have an intentional transdisciplinary approach. So the people who are working on moral philosophy and the people who are working on law, they're in two separate specialties, and then within those specialties there are further specialties. You get this in every field of learning. It's like, how much does the physicist know about the work of the biologists, and what do they know about the work of the chemists or the geologists or the astronomers? How do you know that there aren't things in this specialty that are in contradiction to things in this other specialty, unless there are sufficient numbers of people working on the integration of knowledge and a transdisciplinary approach to knowledge? Now, I think that for law to be most effective, or for, and for us to get the jurisprudence right, the philosophy of law, what it is, how it should function, law has to remain integrated with our understanding of justice. It has to embody the ideal of justice. And justice has to be properly viewed as part of morality. And morality doesn't exist in a vacuum, it is part of religion. So it's a bit like the branch on a tree. If you chop a branch off, it'll wither and die because it's disconnected from the rest of the tree and ultimately from the roots. So positivistic law that says law just describes the rules we make and follow and the authorities that issue these rules doesn't inform us well enough. Law should be a reflection of justice. It should embody the ideals of justice. It should be the closest thing. The people within the law should be preoccupied with questions of justice. There are some jurisprudence thinkers that are more inclined to this way of viewing things. They're the natural law theorists. They believe that there is such a thing as natural justice and natural law, and that our human reason is capable of knowing what justice is and what right and wrong is. So you've got the conscience telling you right and wrong, and you've got human reason, which is an attribute of human nature that can tell you what is just Is it just to defraud somebody? No. It can tell you not only what is just, but why it's just. You can reason to it. If you don't respect the integrity of persons, it can tell you that's wrong, because life is a value, for example, and the protection of life has to be a value. Therefore, the claims of justice must stand opposed to any destructive action against life. So the natural law theorists say that, well, yeah, the law is what human beings make, but it has to be informed by justice to some extent, and we need to put justice into the picture, bake it into the cake. Justice is one of the 4 cardinal virtues in the Western tradition, as we keep reiterating. Justice, temperance, fortitude or courage, and prudence, where we get jurisprudence there as well. Now, these 4 virtues that have been known since ancient times, extolled as the virtues, were supplemented to make up a septenary, a group of 7, in the Christian tradition by the addition of the 3 theological virtues of faith, hope and charity. So you had the 4 natural human virtues, and then you had the 3 virtues that came by grace, by something from above: faith, hope and charity. But because there are different religious traditions, and some people believe in God and some people don't believe in God, a good place to begin is with the natural law, with what human reason can understand. Obviously, I think that justice has to be understood within a moral system. And justice is preeminent amongst the virtues in a moral system. But then a moral system doesn't exist in a vacuum. As I say, there are always epistemological and metaphysical underpinnings to a moral system. Now, for most people, that comes from their religion. A morality is usually associated with a religion. And but even if you don't practice a religion, you still have a philosophical framework undergirding of your morality. It's called metaphysics and epistemology. There must be some worldview that supports your morality. It might just be affirmatory of life, because you believe that we're here, we have life, it's a value, we're geared to survive and to thrive, and there's so much that you can derive just from that alone. Because if life is, say, the ultimate value, then everything has to be ordered to that ultimate value. So anything that makes it easier to survive and thrive is on the side of good, and anything that thwarts life and survival and thriving that diminishes the human being and their capacity to live is evil. And you can reach those conclusions without bringing in God. But they sit quite comfortably within a religious framework as well. So, traditionally, there are different limbs to the law in two of the great monotheistic religions, Islam and Christianity. And in the next video, our final one, we're going to look at the different sources of law.